plus about 10 or so heads of non-governmental organizations, of NGOs, met and were invited to meet in an informal setting to talk about the proposed protocol document, written document, that was prepared by the chair who had been named for that official session. 6 months before any formal treaty meeting, it's the job of the chair to get a draft out of whatever's going to be talked about, so that countries can do their internal thing, so that they're prepared and ready to speak when the formal meeting occurs. The problem for those of you who've never been at one of these formal treaty negotiations, not just climate change, is that a country that spends 6 months getting the internal agreement necessary between their foreign affairs office, their environmental people, their economic development people, sends somebody with a speech to read. And so you get 193 speeches in a row in 2 weeks. And not one of them has anything to do with what the other 194 say in the meeting, because they were prepared over 6 months before anybody ever went to the meeting. And the only thing useful happens at night at the bar. Because officially, the last thing a negotiator would do is not read the document. I mean, they get called home, yelled at, and fired, and replaced. So they got to read the document. Even if by the time you're 187, your turn comes up having signed up, nothing you're saying is relevant anymore to anything that's been said and been discussed at the bar in the evenings during the 2 weeks. But prior to this informal session, in which about 15 or so of the official country negotiators were meeting, because they were invited to come, prior to this session, a series of background papers were prepared by a group of independent scholars from different countries on different issues, working on different issues, on topics of key concern to the official negotiators. Think about that. Most of these negotiations, the negotiators come armed with what they need the truth to be on the scientific and technical issues. But this was different. This was a mixed group of professional academic scholars who were taking the issues of greatest concern to the official negotiators, who were coming to this informal meeting to talk about the parts of the text that had been set out that they had problems with. To talk together about the problems with the text as it had been composed and distributed by the chair. These technical experts were commissioned to write these pieces based on interviews that the Consensus Building Institute did with these official negotiators. Confidential, not for attribution, off the record. So tell me, what really do you think the problems are with this text? I'm not going to quote you. Or problems with section 14, paragraph 3, or we have problems with this issue. And if you interview key negotiators from all the different parts of the world, and you could isolate issues in which there's problems, and you could commission a set of background papers, not on behalf of any one country, not on behalf of any one view, but to try to lay out what do we know, what don't we know, with regard to the issues of greatest concern to the group. And then everybody who's coming to this informal session gets these papers to look at. The parties, that is, these people were invited to attend in their personal capacity. And you want an official governmental negotiator to attend in their personal capacity. Two things are absolutely crucial. One is, you've got to pick a really, really nice place that people want to go on their own time, because they're not going in their official capacity. Saint-Tropez. It's really nice. Secondly, you got to pay for everything. You can't ask them to pay, because if they have to pay, then they got to go to the government. If they go to the government, then they're there in their official capacity. So you got to put the funds together, pick a really nice place, pay close attention to the official meeting calendar in relation to all these groups. So you pick a long weekend where you're not in conflict with one of the preparatory committees or something else. So we had American Foundation support. We could invite people in their personal capacity. We could commission these papers. We could do what we would call the stakeholder assessment beforehand by interviewing people confidentially, not for attribution, to put an agenda together to commission the papers to structure what the talk was going to be about. And the chair of the Kyoto scheduled event also came. The end result of that long weekend was a booklet with suggested alternative language to key sections of the draft protocol, produced through informal conversation amongst these carefully selected dozen or so negotiators and another dozen or so non-governmental organizations who are not officially players in treaty negotiation. Treaty negotiation is an act of sovereign states. Now, if you go, especially in recent years, to one of these treaty negotiations, there's the people sitting around the table, and then there's 10,000 other people trying to influence what's happening who have no official standing, but are standing around the room. 1972, the first time we did a environmental treaty in Stockholm, about 15 miles away at a campfire were the non-governmental organizations. And secretly at night, Barbara Ward, who was an official negotiator, went without telling anybody and met around the campfire with some non-officials to tell them what was happening. And then if you go from 72 to 1992 in Rio, you have several thousand non-governmental actors in a separate building right next to the official building. They'd moved from 15 miles to right next door, and some of them were trying to get into the actual building where the negotiations were going on. You go to Kyoto and Stockholm and Cancun, you're in the room. They don't have a vote, they're not officially sitting, but they're around the room now. They're not in the next building. And some of them have even been invited to sit with delegations from countries, particularly developing country and small island nation groups who don't have the staff that they would need to compete with the 400-person US delegation that arrives when other countries come in with one person. The end result was this booklet that the facilitation team published with nobody's name on it. But one thing we made sure of was it had this garish day-glow orange cover. There was a reason for that. So that when you went to the formal negotiations, you could see at this distance, at every table, who had the booklet. So people could refer to, did you see that? Did you see in here this language for this section? Oh, cool. You saw that. What did you think of that? Has no official standing of any kind. That's my first story. Second story. In Alberta, Canada, anyone unhappy with the actions taken by the Provincial Environmental Agency can't challenge administrative decisions in court the way those of us in the US are used to imagining. You don't like an administrative decision, you go to court. And you can argue that the decision was arbitrary and capricious so that they can follow the right procedures. And we've liberalized the rules of standing so that almost anybody, whether you are hurt or not by that action, can go to court and complain about an administrative decision. Can't do that in Canada. Canada has a different model. They create an appeals board, and it sits like an administrative law judge on top of the agency. They have it for a lot of different functions. So the environmental agency has an environmental appeals board, which is a politically appointed board that hears appeals with regard to those decisions. It's not like going to court in the US sense. Environmental Appeals Board, some decade or more ago, found itself swamped. The more laws about environment, the more regulations about environment that an agency passed, the more appeals there were. To the point where this board, which wasn't getting any bigger and wasn't getting a bigger budget, couldn't hold all the formal 2 or 3 day hearings that it needed to hold. It cost $30,000, $40,000 to organize 3 or 4 day hearings in the capital, in the provincial capital, to hear each of these complaints. So they contacted CBI and they said, can you think of any way we could process more of these complaints in a more timely and efficient fashion? And we said, well, you could mediate them. And they said, we don't think we're allowed to do that. That is, they said, we don't think we're allowed to take what we're supposed to do as elected appeals board members and turn that over to some neutral party. And we said, you ever settle any of these appeals? Oh, all the time. So we have the power to mediate them. But it doesn't say the word anywhere in our enabling legislation. Oh, but if you can settle, you can mediate. It's implied. It set legal scholars to work for a year on that question. In any event, the appeals board said, what can we do? And we said, well, you can mediate. And they said, we don't think that's right. And they said, well, what about if we mediate? We, the board. We said, well, there's a couple of problems with that. One is you don't know how. And the second problem is, if it doesn't work, then the board would have to hear the case. And they said, well, what if one of us tries to mediate, and if it fails, that person has no communication with the other members of the board, and then the board has to do its thing, then it can do so independently of the mediator. We said, well, but there's still the first problem. You don't know how to mediate. They said, teach us. So we spent 3 years teaching the 7 board members to mediate. 3 were good at it. 4 were terrible at it. They all tried. But the 3 who were good at it started mediating. And as the reappointment of board members happens, it's 5-year terms. It's not life terms. 5-year terms, as the appointments happened, they began to add as a consideration whether board members would be able to mediate. I kept arguing for them to create a roster of independent mediators and send it to them, and they said, no, this statutorily we're responsible for making these decisions. We just don't see it. I said, well, the mediation could propose something, and then you could review it. No, we have to do this. So no matter how many times I argued it, they decided they needed to mediate. Well, today, 80% of all appeals are mediated effectively. And we have been monitoring and evaluating all those results. There's a long article in the Dalhousie Law Review describing the whole history of this and our evaluation for 7 years of what happened and so on and so forth. And now other appeals boards in other arenas, immigration appeals boards, tax appeals boards, are all deciding they too have the power to cause mediation to happen. And not all of them are as rigid as the Environmental Appeals Board about the use of neutrals. The interesting thing about appeals is they happen all over the province. The province is big. Geographically, it's an issue to have to come down to the capital and pay and wait for 3 days of formal adjudication. The mediation happens in the site, in people's dining rooms, where they can have their friends nearby in an informal conversation to see if some resolution can occur. And while that's uncomfortable for the agency personnel who are required to show up to represent the agency in the mediation, it's a lot more comfortable for the people who had the problem. And it seems to be working very nicely. My 2 examples are designed to suggest that informal problem solving, added as an extra step, not as an alternative to, mandated policy making, complaint handling, or administrative procedures, can help to generate agreements that would otherwise elude the parties. And the trained mediator